Yeah, namaste everyone. Thank you for joining. My name is Nikuj Trivedi. I'm the president of CoHNA, or Coalition of Hindus of North America. We are a grassroots advocacy and civil rights organization advocating for a better understanding of Hinduism and working on matters impacting our community. As many of you had heard, this past Monday, there was a major development where the California Civil Rights Department decided to dismiss their case against two Cisco Indian engineers. The case, as you may have heard, was filed in 2020 that alleged that the two Indian engineers were basically discriminating based on caste against John Doe, who has not been identified. So the case had gone through a bunch of different things, which we will talk about today, and that resulted in a massive, I would say, publicity around grave caste discrimination or alleged grave caste discrimination in the United States. And the case has been used as a poster boy, essentially, for pushing for policies and laws around caste discrimination in the United States. So we will talk about some of that, what that means, what the case is, and what people should be thinking about and what they should be concerned about, where the case stands, but what can happen after this. So with that, I wanted to introduce two of our panelists today. One of them is Suresh Krishnamurthy ji. Suresh ji is the member of the board of directors and a treasurer for CoHNA. And Suresh ji has been closely monitoring this case since it started, and has developed a lot of understanding behind kind of the scenes. And he has done a lot of research around not just the case, but the surrounding background about who the groups are, what they have been doing, what the case was about, what the defendants themselves had done, et cetera, et cetera. So he's here to break down this information for us. And I also have the pleasure of welcoming a young Hindu lawyer. His name is Vivek Rajan. So Vivek is basically a Hindu American based in California. He's an attorney by profession, and he's a young guy who's trying to make a change in the diaspora and is interested in issues around this particular case, but also in general, and how he can be of service to the community. He also tweets as Duke of the Diaspora on Twitter, so you can follow him there as well. So Vivek, welcome. So happy to have you join. So Suresh ji, take it from here.
Okay. So you shall, I'm sure you're all seeing a screen share. So what exactly was the case? Basically, the California Department of Fair Employment and Housing, that's what they used to be called 3 years ago. And they're the plaintiff. So they have alleged in 2020, they alleged that Cisco discriminated against John Doe, an employee of Cisco, based on national origin and ancestry. And when John Doe complained that he was being discriminated against, they basically retaliated against him. So that was a central claim in the case that was originally proposed. Now, in that, they added a twist. They basically said, okay, what was the basis of the discrimination? So they technically said it's based on national origin and ancestry, but in reality, they said it's actually based on something called caste. So some of the key allegations, and these are important because they play into why the case got dismissed. One was, it said, except for John Doe, the entire team are from high caste in India. So they basically claimed that Cisco simply had no one but high caste Indian employees, and John Doe was his lone Dalit warrior who was, being preyed upon by all these upper caste Hindus, right? And then when John Doe complained about it, they failed to take steps to prevent, and they quote, inequalities associated with caste status, ritual purity, etc., social ostracization, etc. And in this, they have lifted the language directly from a report that was published by Equality Labs back in 2018 called Caste in the United States. So for the first time, there was an official legal pleading that said what is said in the Caste in the United States report is factual and can be the basis of a legal finding, which is a huge bar to cross. So once something gets established as a legal precedent, then the floodgates kind of open and everybody can point to the precedent and say, hey, look, that's where it is defined. So what was alarming to us was this case, when it first came out, it literally mainstreamed and legalized that report. And that report has a huge number of flaws, as we will see later. The lawsuit also said, not just content with going after Cisco, they went after individual managers. The two managers that they went after were, their names were Sundar Iyer and Ramana Kompella. And basically, the lawsuit claimed that Iyer and Kompella are, upon information and belief, Brahmin. This is important because this is for the first time in US, jurisprudence and US history, a defendant is being assigned a caste by the state. It says, literally, it says in the complaint, upon information and belief, Iyer is a Brahmin, Ramana is a Brahmin. They don't differentiate between high caste and low caste. They just use the term high caste. They use the term low caste without necessarily defining what is high or low. But the most important point they made was, irrespective of what you claim, or at least implicitly what they were saying was, irrespective of what you claim, we are going to tell you that you are a Brahmin, you are upper caste, and therefore the presumption is you are discriminating. Okay. It also states in the complaint that caste is a strict Hindu social and religious hierarchy. This language is very critical because in the US, of course, the state is not allowed to single out a language, single out a religion, either for endorsement or for blame. Here, they're clearly blaming Hinduism as it is a strict Hindu social and religious hierarchy, meaning, at least from California's point of view, or at least from the Cisco case's point of view, this is strictly a Hindu thing. It's got nothing to do with Muslims or Sikhs or whoever, Hindu, right? John Doe claimed he was out. So how did the case actually happen? What were the facts of the case? There's a lot of rumors floating around. So let me kind of break it down. Sundar Iyer and John Doe went to IIT Bombay. They both graduated from IIT Bombay as classmates. During that time, apparently, and I did not know this, I mean, I went to IIT, and when I went to IIT, nobody cared whether you were from this caste or that caste or this list or that list. But apparently, Sundar Iyer was aware of the fact that John Doe was from a scheduled caste. Okay. Well, Sundar Iyer actually recruited John Doe for a high visibility engineering position at Cisco. He was recruited into that position, and things were kind of going along. And John Doe suddenly felt that his status as a scheduled caste has been outed, and therefore he felt put upon. He went and complained to HR, saying that my boss had no business disclosing the fact that I'm scheduled caste. They investigated, and they came back and said, this is not discrimination, it's a fact. The fact, you can't be accusing somebody, you can't accuse somebody of discrimination when they state facts. And it is a fact that you are from the scheduled caste in India, however it's defined it, and that's the end of it. Besides, and this is the language they added, besides, caste is not a protected category under which you can sue for discrimination. Once that language was added in the complaint, then it was off to the races. They were basically, people were saying, hey, wait a second, the only reason they did not file it as a caste-based thing is because caste is not protected. So we now have to go and protect caste as a special category in all our discrimination cases. When Cisco's investigation came back nothing, they investigated once, twice, it came back nothing. There were a lot of other factors which we will get into, but at the end of the day, the CDFEH essentially said, Ramana and Sundar Iyer discriminated against our client. Okay, so let me step back. John Doe is not the client of CDFEH. CDFEH is bringing this action independent of John Doe. They are acting on behalf of John Doe, but they are not bound by what John Doe believes or does. They are simply saying Cisco is discriminatory and two of its managers have acted in a discriminatory fashion against one of their own employees. That was the case when they filed it in 2020. Well, Cisco argued that, hey, wait a second, we have a rule that every employee signs that when they join, Cisco, they have to agree to binding arbitration as a way to mitigate these issues. And anytime there's an issue between an employee and the company, it has to be dealt with through binding arbitration. Binding arbitration is when you get an independent judge who will listen to both sides of the case and simply say, this is what you guys should do. That's the end of it. It doesn't go to court, but it is arbitration. So Cisco said, no, this has got to be done through arbitration. And Ramana and Sundar said, why does John Doe get to hide his identity when we don't get to hide our identity? So both of these motions were filed. They were rejected by the state court. And actually one was rejected, one was upheld. The idea that it has to be binding arbitration was rejected. And the idea that John Doe had to be, he was going to be anonymous was also rejected. So they both got appealed. And when they went to appeal, they sat in the appeals court for almost 2 years. And the appeals court finally said, okay, that's it. No, John Doe is allowed to be anonymous. And no, you're not subject to binding arbitration. Again, a very technical legal point. This is a suit between California and Cisco, and California is not a party to binding arbitration, therefore no binding arbitration. So they kick it back down, right? So, and when they kick it back down, this is what happens, right? Both appeals are lost, 2021, 2022. The case has come to state court. So by the time June of 2022 rolls around, it is as if the case has been filed new. There's been no hearing. There has been no motions that have been filed or appealed or the thing that actually deal with the case. There's not been a single day of argument. There's been no jury impanel, nothing. All it has involved so far is a bunch of lawyers filing paperwork saying this case should not even come to court. So once the state court said, and once the appeals court said, yeah, the case can go forward, Sundar and Ramana filed a separate motion saying, this has gone on for 3 years. We have provided very specific evidence to the CDFEH that contradicts the specific claims in the lawsuit, and they are willfully ignoring it. So you should sanction them to the tune of like 10 grand. It's a nominal sum, but a sanction is a big thing. As soon as that motion was filed, CDFEH, now called CRD, now started negotiating furiously with Ramana and Iyer. And in December, there was a case management conference, December 2022, where they had at least implicitly said, we're going to dismiss the case against you, against Sundar and Ramana. And then in January, they kind of rescinded it, which is when Sundar and Ramana filed their motion for sanctions. And after the motion for sanction, the CDR quietly came back, the CRD quietly came back and said, never mind, we are withdrawing the case. It's as if the case never happened. But we're still keeping our case against Cisco open. Well, that's kind of moot because Cisco's part in this was that of a company that did not follow its own rules or something like that. Even before Ramana and Iyer had filed their motion for sanctions, Cisco had negotiated mediation with CDFEH to make the case go away. So at this point, there's no arbitration. There's a mediation offer on the table between Cisco and CDFEH, CRD. And the defendants are saying, you have no case against us at all. You should never have brought this case, so dismiss it so you can never sue us again or ever on this particular charge. Come April, that is exactly what happened. Before the case proceeds to trial, the case against Iyer and Compella is withdrawn by CDFEH. But they continue with the case against Cisco. So if you think about the motives of why you would pursue a case against Cisco, is what does the CRD want from Cisco? They want Cisco to spend some money. They want Cisco to say they won't do it again. They'll be good people, good boys and good girls, and they won't do it again. And most importantly, they will have a program that educates their employees and staff on caste, what caste is and how it can manifest and all that kind of fun stuff. The catch there, of course, is that this quote unquote training will be provided by organizations like Equality Labs because they've done a really good job of positioning themselves as caste experts. So the circle is now complete. Equality Labs instigates the state of California to sue Cisco and the two employees. How do we know this? Because they are very specifically referred to in the complaint. And I am very positive that CRD didn't magically discover the Caste in the United States report and then use that to say, oh, wow, we can go after Cisco. No, they were told to go after Cisco and they bought it. Now, the CRD itself in California has gone through a lot of turmoil over the last 1 year. And this might explain why they reversed course and did not want to risk a jury trial where they'd have been embarrassed, right? Apparently, the head of CRD in California was defying the orders of the governor. And the governor actually fired the head. And the co-head, who happened to be Melanie Proctor, who was the prime mover behind the Cisco case, she also quit in protest. And that opened up CRD to negotiate and clear off a lot of these totally unwinnable cases. Right? So, this is where the case stands right now. The CRD has said there's nothing against Iyer and Compella, basically saying, oops, never mind, there was no case. They are still going after Cisco because Cisco is deep-pocketed and because Cisco's interests are a little bit different. They want this whole thing to go away. They don't really care what they put in their policy and what they don't put in their policy. They can pay money and make this go away from becoming bad publicity. That's where they are. Right? So Cisco has every incentive to settle this during the mediation session, which is what I expect will happen. They'll both sides will declare victory. Cisco would have agreed without acknowledging guilt, and CDFEH would have successfully prosecuted a case against Cisco. I think that's how this whole thing is going to end, right? Okay, so that was a timeline. What are the key takeaways? What we found out, I mean, if you look at if you take an objective view of this, what we found out was the report Caste in the United States has somehow become mainstream. It is now become the go-to reference for anything to do with caste. And yet that report has huge flaws. And that's a different topic for a different day. But at the very least, people should note that the Carnegie Endowment, which also does surveys much more scientifically and much more organized, they were very critical of the survey, suggesting that the way the survey was structured, it attracted comments and it attracted responses from people who already strongly felt caste was a problem. This was not a neutral question. That was their biggest complaint. Biggest knock on the survey was this was not a neutral complaint, neutral survey based on random samples. This was a highly targeted survey based on activist populations. And then to claim that somehow that is widespread evidence of systemic caste bias is just ridiculous on its face. So we kind of reject that argument, but it's an important argument to make and understand where the funding or where the push may be coming from. And it certainly, Equality Labs is a big deal. The second key takeaway was Iyer and Compella were tried and viciously attacked in the court of public opinion based on a single unsubstantiated allegation. And in this case, the accuser is also allowed to be anonymous. Sundar Iyer and Ramana Compella's names were presented as evidence of incorrigible castes at the Dismantling Global Hindutva conference last year. They were literally doxed on the conference materials, saying these two guys, along with everybody with the name of Trivedi, Chatur, then there were a couple of other names they threw in, were all automatically casteist. Yeah. this was an interesting takeaway because we did not think that people would be brazen enough to make that claim, but they did. Just based on a last name, you're now automatically assumed to be a casteist unless you can prove otherwise. We also noticed that the Cisco case was the linchpin for every action in every city and state legislature that recognized caste, or university that recognized caste as a problem. Why is that the case? Because everybody kept pointing to Cisco. Finally, a big IT sector player is being sued for caste discrimination. That must mean there's caste discrimination. That must mean that it's endemic, and we were right all along. Sundar Iyer actually wrote a blog article 20 years ago when he was studying at Stanford, where he said, I do not follow organized religion. I refuse to identify myself as a Brahmin. I never had the thread ceremony, and so on and so forth. So he happened to have a body of work that literally opposed the claims that were being put on him. He's saying, you're telling me I'm a Brahmin. I'm telling you, I don't even believe in the concept. Okay. But that didn't stop CDFEH. And that's something you should remember, because if the state can ignore you completely and assign a caste to you, well, what is your defense? How do you get out of that? Because when they assigned a religious identity to an atheist, and then also connected caste to Hinduism, then essentially what they are saying is Hinduism is a caste-based religion. The upper castes of Hinduism can never deal with the idea of lower caste being successful, and we are going to come in and prevent it with a law. In reality, they're playing to an audience that they want to capture, the youth vote, and maybe they succeed, maybe they don't. But at the end of the day, it is, or at least the institution, it is definitely politics. Okay. So why should you get involved? Right? All the people on this call, why should you get involved? Because it can happen to you or your loved one. And we know this is true because Ramana Kompella and Sundar Iyer just spent 3 full years being hounded in public for something that they did not commit. And finally, the state admitted they did not commit. But their 3 years was completely lost down the drain because somebody was overzealous. The other reason to get involved is the politicians are only hearing one side of the story. If you see Aisha Wahab's press conference, she's surrounded by people who have given her input, such as Thenmozhi Soundararajan. She's right there on the front, sitting down right next to Senator Wahab. Right? So politicians generally are hearing only one side of the story. We need to get involved so we can tell them the second side of the story. Hinduism is being described as an inherently oppressive religion. So even with all the hand waving and all the wink and the nod about, oh, we are only opposed to Hindutva, not Hinduism. Sorry, guys, in the minds of the average Western folks, there is no difference between the two. It's the same. And at some point, if they say we are going to ban Hindutva, they're going to turn around and say, well, how about the Hindus? You're going to ban them too? Okay, so Hindutva and Hindus, obviously, apart from the linguistics connection, are also tied very, very, very closely with each other. So the idea that somehow this bill will just kind of disappear and I don't really have to do anything. No, you have to do something because otherwise the bill's going to pass. So Sundar Iyer happened to have written a law when he was young. He happened to have written that he was an atheist. Should we now all be expected to declare that we are atheists and that's why we can't be sued? Are we not allowed our religious rights to be a Hindu? And do we not deserve the opportunity of not being sued for discrimination and then asking me to defend it? Right? So at several levels, this particular law, SB 403, and California being the size of what it is, passing it in California, and it's no coincidence, by the way, why California was targeted. Passing it in California will mean multiple legislatures around the country would be looking at it closely saying, maybe if California did it right, we could copy that. Okay, so when we talk about why you should get involved, it is very important for people to get involved to head the equality labs of the world at the past, because they're going to come to your HR department. They're going to come to your HR department and tell your HR department that your firm needs to be educated on caste, and by Joe, we are the right guys to do it. So pay us $500,000. And DEI programs around college campuses are almost certainly going to make it mandatory to discuss caste. So there's a monetary aspect of this. So given all of this, why exactly, knowing the timeline of the rule, right? Knowing the timeline of the whole case, what happened ultimately, that I hope I've been able to convey the difference between arbitration and mediation. Arbitration is binding, mediation is not. I hope I've cleared up the confusion about what did the Superior Court actually say. For example, Chama Sawant was saying, oh, the Superior Court had now given permission for the lawsuit to proceed. No, they did not give permission for the lawsuit to proceed. All they did was rule on a couple of motions that would have taken it out of the court altogether. And they said, no, that doesn't apply here because the plaintiff is not party to the arbitration claim. Okay, so that was simply not the case. Why is this relevant for SB 403? Because like I said, if SB 403 becomes law, who will be the next Sundaraya? Who will be the next Ramana Kumpela? It could be any of us on this call, or people who are not even on this call. Right? So it is crucial. It is crucial to remember that this law, if it gets on the books, is targeting a micro minority in the United States for some alleged sins that their forefathers may have done in India. Okay, that is the primary motive, primary mover behind all of these various actions. Right. So let me take a breath and stop there. Let me open it up to Nikunj and Vivek.
Yeah.
Want to add something?
No, absolutely. I'll let Vivek talk, and then I'll kind of come back in. Vivek, you want to share your thoughts?
Yeah, I mean, I think Sureshji covered it excellently, start to finish. You know, it's really nice to see that they did withdraw eventually. I think what we should really be focusing on now as a community is going forward, SB 403, as Sureshji just mentioned, sort of in the backdrop of this, we have SB 403 coming in. I think that's where we need to turn our attention to. And we also need to be very cognizant of the fact that we didn't get a judgment on the merits here, right? Because this was sort of voluntarily dismissed, and so it's still on the books that, you know, another company could get targeted, right? And I'm sure 100% that, you know, if this does happen in the future, you know, let's say SB 403 doesn't happen, right? So there's nothing, or let's say it goes through regardless. The next lawsuit that happens, I do think that we will probably see another lawsuit like this in the future, to be honest. I think those attorneys will be looking at the motion for sanctions here, and they'll be making sure not to, you know, make the mistakes that the CRD made in this instance. I think the attorneys representing Ayer and Kampala did an excellent job here at Rothschild with the motion for sanctions. I thought it was incredibly well written, to the point. And I think it's going to be one of those things that attorneys look at in order to make sure that they don't go down the same route. So we just have to be very careful, because I do expect it to pop back up, and then also SB 403 coming up. So these are two things that we need to be careful of. I don't want us to get too excited in the way that we think that we got some sort of judgment on the merits and now something's, you know, concrete. So.
Yeah, agreed. You know, one of the things I would say is, and Vivek, this is a question for you as a young Hindu American, you know, sort of born and raised here. What are your thoughts on this case, like in terms of your identity, your religious rights, you know, all that stuff? Because a lot of times people talk about it, you know, the problem is with quote unquote immigrants. And I push back on that part, but I also say that, you know, what about people who are born and raised here? What about them? Right. So you want to share your thoughts on that?
Yeah, it's incredibly worrying. You know, the idea of caste is something that hits, you know, pretty close to home, but in terms of my parents moving out to North America. And it's something that when they moved here, they they wanted nothing to do with, right? And so we're here, we have, what we believe is equal opportunity in this country. And for us born and raised here, when we see things like this starting to pop up, it's incredibly worrying. And, I'm out of school, but I'm thinking to my future, right? My kids. If we start to see these sort of policies in place, then it's worrying for them. It's still worrying for me as well. And I think it's on us as like Hindu Americans, Hindu Canadians, anywhere in the diaspora to start speaking about these issues, because they need to know. I think oftentimes the immigrants are targeted so much, right, with the whole HB1 visa issue that was going on a little while ago. I think it's still currently going on. The immigrants that come in from India are targeted. I think caste is one of those things that's going to target every, whether you move to India or whether you're born here, if you're of Indian origin, ethnicity, it's going to target you. So I think we have to do a lot more. It was incredibly worrying, and that's why I started to look into it. And it's time to do something about it. So.
Yeah, no, I agree with you. There's so many layers in this case, and I urge everybody to go to castgate.org. The individuals behind it, I guess, have done a fantastic job in cataloging this entire case and the fraud that was committed by the California Civil Rights Department. There are so many different things. Today we're just talking about just the case, but if you look at some of the stuff that is on there, you will realize how these two were framed and the entire kind of like infrastructure that was put against them to make sure that they never see the light of day as far as this discrimination is concerned. They were basically put to the cross, so as to speak, as in the American parlance, you may say, without defending themselves. Now, what I did was I put a link on the chat, and I want people to go to that link. And the reason I put that link is because there is a claim out there that there is no this SB 403 does not target any religion. Why are you against it? And so on and so forth. Let's talk about that a little bit. First of all, it does target particular ethnicities. For example, it says caste is especially prevalent in South Asians. While it may mention other regions, it targets the South Asian community, number one. Number two, California Civil Rights Department and the state of California has already assigned religion to people who are not even Hindu, and just because of their last name. So that has set a precedent that can actually happen with this type of a law, because now you're going to have a law versus something else before. Number two. Number three is, as I posted on the chat, that's a declaration by Tenmori Sundararajan of Equality Labs. She actually, in the declaration, she supports the fact that John Doe should not be outed, meaning his identity should be protected because he's going to be subject to attack and blah, blah, blah. But what she does there, she actually blames Hinduism for the caste system. And there's a whole paragraph, I believe on page 6, where she says caste is a form of social exclusion that derives from Hindu scripture. So when people say that, oh no, there is no discussion about caste in Hinduism, so why are you against it? The people who are pushing this agenda, this entire law, have very specifically defined caste as equal to Hinduism, or Hinduism equals to caste, and so on and so forth. And the state of California has actually defined religion and defined caste as equal to Hinduism. So that's where the worry comes in, because the state has already gone down that path. The other piece that people actually talk about is, well, why not include caste? Because there is no current categories to protect against such discrimination. Is very unique, things like that. So the answer to that has been a few things. Number one is the data is lacking, and the only data that's out there is the Equality Lab survey and a bunch of anecdotal data, that's been essentially put as part of a straw man argument as far as this is concerned. And that's number one. Number two is, there are already categories. If you look at the Cisco case, and I urge everybody to read the motions for sanction, we'll put it in the chat again. The Cisco case actually was tried based on national origin and ancestry. So if you say caste is hereditary, then you should be able to file a complaint based on ancestry or national origin or national origin. Now, we haven't seen that any cases. I have asked for people to show police reports, any cases that have been filed that have failed so that you need a special category and things like that. None of that actually has happened. So that is lacking. So just going and creating a law based on some groups that are openly anti-Hindu and openly hateful is just not right. And there are certain agenda-driven activists and political leaders behind this that are pushing for this particular law to be passed, because once it passes, as Surajji said, in California, other states can follow suit. So, when people, and finally, from 6th grade onwards, when someone grows up in America, you learn Hinduism equals caste, caste equals Hinduism multiple times. Media also confirms the same thing. If it's not Hinduism, it's at least India. So when there's implicit bias ingrained in the people who have been learning and going through the American education system. So anybody who's going to be looking at this, neutrally, it's not possible, because they cannot help themselves connect this with Hinduism. And of course, the last names and how do you define this caste? There are a lot of different issues, and that's the reason why we have been against SB 403 and have been opposing this as much as possible from our end. The idea that caste discrimination somehow is a grave problem in America, unfortunately, doesn't exist, and there is really no data to prove that. We stand against all forms of discrimination. That includes discriminations against Hindus. And if you are going to put a law out there that singles out a particular ethnicity or a religious community and so on and so forth, that is a fundamental violation of our civil rights, and we will fight against that. And we urge all well-meaning Hindus and people who are allies of the Hindu community to come out and be against this, because existing law already provides the protection that is needed to fight such discrimination against anybody out there. So what we'll do is, there are a lot of questions, and I don't want to be mindful of time.
Yeah, I'd like to take a couple of those questions and answer them live. I think a lot of people have asked some variation of this question. Why can't we sue the CRD? Why can Sundar Iyer and Ramana Kompella sue, saying, can we sue Equality Labs, for example, for providing wrong data and so on? So I want to take that question on. And the second question people have asked is also, why is Cisco leaning towards settling rather than fighting back? So let me take the first question first. In the United States, obviously, anybody can sue anybody for any reason. The real question is, will they prevail in a court of law? And in order to prevail in a court of law in a civil lawsuit in the United States, and this was largely done to prevent frivolous lawsuits from coming forward, is you have to prove three things. You have to prove that you were harmed, there was real harm done to you, or there is imminent harm done to you, right? That will establish what is called standing, is, hey, I have the standing to sue this because I'm affected by this, right? You have to be in the right jurisdiction. So if you're affected in California, you can't sue in Seattle and vice versa, right? That is a second pillar on which it stands. And the third pillar on which it stands is, it has to be actual harm. It can't be theoretical harm. It could happen, it might happen. It has to have actually happened. So there's no way to sue Equality Labs because they just provided the data. They haven't really done anything that is quote unquote, or at least has a reasonable shot at prevailing in a lawsuit, right? So that's not going to happen. In terms of, can Sundar and Ramana sue? Yes, of course they can, because the case was dismissed with prejudice, which means the state will never sue them again for the same reason. But by the same token, there was no clause of a agreement that the defendants would not sue the state. However, we have to think about whether or not, after having spent 3 years fighting in the courts, do you want to spend another 3 years going after CRD? And for what? I mean, to prove a point. I think from Sundar and I don't have any personal first-hand knowledge of this, but I would guess that between Sundar and Ramana, they're probably sick and tired of lawsuits and lawyers and courts and filings and stuff like that. So is it likely? Is it possible? Yes. Is it likely? My guess would be no, I don't think so. The other question was, why would Cisco agree to caste re-education as part of the settlement? Any large corporation in the United States, their first goal is to make lawsuits go away. That's it. Unless it's somehow existential, they would rarely want to take the trouble of fighting this out all the way to the bitter end. I mean, if you look at this thing from Cisco's point of view, what does it cost them? Nothing, just a few words added to a policy. And then when next time when somebody says, you know, there's a caste-based discrimination, they just have to figure out who's upper caste, who's lower caste, whatever. But at least they've checked a box. They are now the progressive company. And most importantly, the lawsuit goes away, right? So from those three perspectives alone, it makes all the sense in the world for Cisco to come out of mediation with a big fat check and say, let's put let bygones be bygones. We have made they've already made the change in their policy to include caste. Their policy has already been changed right after this, right? So they don't really have anything else to do other than to pay John Doe a certain sum of money, whatever that sum of money is. The irony is, all of the people involved in this case, Ramana, Sundaraiyer, John Doe, they're all multimillionaires. These are not exactly poor people waiting for the next paycheck. These are people making, you know, big 6- and 7-figure salaries. And yet, John Doe wanted us to believe that he was really upset because he did not get $2,000 in increment. So go figure, right? So if the question is why would Cisco agree? Because they like to make lawsuits go away. And while staying on the subject of lawsuits, just to clarify, was there not a suit filed by HAF in the same case? Yes and no. Yes, there was a suit filed by HAF, and no, that had nothing to do with Cisco directly. HAF filed suit against CRD and the state of California, claiming that the idea of suing Ramana and Sundaraiyer based on a caste claim is itself discriminatory. They were basically making the claim the state has no business saying what belongs and does not belong into the Hindu religion. Right? So that's a separate lawsuit that's still hanging out there. Who knows how that's going to be decided or when that's going to be decided. But that is more of a technical point that HAF raised, saying, by the way, this is unconstitutional because you are now defining what a religion is. What will happen to that case? I don't know. I honestly don't know the answer.
Okay, good. I'm just trying to go through a bunch of sessions. I think somebody talked about the Equality Lab survey. Can you talk a little bit more about kind of what they did, the audience, the sample size, audience for that survey, etc.? Was there any? Do you have any information? So, I mean, you could check out the Equality Lab survey on its own. I believe
I can give a quick summary.
Go ahead.
I'm very familiar with the survey, so I can give a quick summary. So they did what's called a snowball sampling. As in a snowball sampling, you reach out to 50 people, you tell them what the survey is about, and those 50 people identify another 50 people who may be interested in responding to this. And they in turn may identify another 100 people. So the sample or the respondents of the survey are not randomly sampled, but instead they're quote unquote chain sample, right? You sample 5 people, those 5 people suggest 5 other people and so on and so forth. So that's one thing. The second big flaw, of course, is they had a sample size of 1,500 and they threw out about 300 responses on what I would consider completely flimsy grounds, such as they threw out responses which they claimed, quote unquote, were illogical answers that didn't make sense. When you do a survey, you're not supposed to be judging whether the answers are logical or illogical or intentionally misleading or what. And yet they threw out almost a quarter of the responses that they got on this basis. So that was the second big, huge, humongous flaw. The third one was the survey itself acknowledges on page 39 that it was not scientific or it was not meant for statistical sampling. They acknowledged that this was not tested for statistical accuracy, and they reserve to do that in a future survey. So at this point, all the survey is saying is, oh, by the way, we asked a bunch of people who might have already had grievances, whether they had grievances against caste. Well, what a great surprise. The 2/3 of them came back and said, yeah, we think. And then you look at some of the reasons why people said they were discriminated against are things like they wouldn't invite my child to their children's birthday party, or they stopped interacting with us in public, or they stopped us from bringing a meat dish to Diwali. These were the reasons why people said we need this, we need caste-based. These are the kind of discrimination that people claimed had to be stopped by this legislation. Actual discrimination is very hard to prove, and it is very rare because you got to have a pattern, you have to have an explicit statement made, and so on and so forth. So it's not easy to debunk Equality Lab's report. Well, in a sense, it's easy, but it's not easy. It's easy because the report itself is just utter nonsense. But it's not easy because it's become so embedded in the narrative about caste in the United States that to peel it out of every narrative is going to be really hard. So we're looking at what possible strategies we might have. And speaking of strategies, the only way to challenge a law like SB 403, which, by the way, legislatures are at perfect liberty to make bad laws. Nobody can stop them from making a bad law. You go to court and try to say, hey, they're making a bad law, stop them. The court almost always turns around and says, I don't have to stop them. You have the means to stop them. Don't vote for them. Vote them out of office. Bring in a new team that will repeal it. Whatever you have to do. There's a legislative process that you can follow. I'm not getting involved, which is why it's almost impossible to actually sue a city. Right? So people have been asking us, how come why can't you sue the city of Seattle? Or why can't you take it to the courts? So the only realistic way to challenge this law is on constitutional grounds. There are several constitutional grounds that we have identified are potentially strong candidates to challenge this law with. So stay tuned. We are certainly looking at that option.
So there are a couple other questions which are interesting. One is the question was how can Cisco just add this as part of their policy, and isn't that sort of like harassment for and mental trauma for employees because you did not consult people without, and you just added a policy without any kind of data out there. So Apple and Cisco have done it without consulting the employee community and things like that. So what are your thoughts on that? Can they just go ahead and they just add a policy without consulting anybody? I'm not even sure people know that today.
They can, right? I mean, they're a company. A company can have a policy against anything. That's
right.
It's a private organization. So, for example, there are companies that do not allow, in Georgia at least, there are companies by policy, they do not allow guns on their property. You cannot keep a gun, even if it is locked in your car, on their parking lot. Well, that's up to a company to say yes or no. That is being challenged in court, and that actually failed. But the idea is a company can set a policy around anything, as long as the policy itself is not unconstitutional on its face. They can. So, for example, in fact, companies are not even bound by free speech laws. This is something that a lot of people find surprising. They say, well, how come a company is not subject to the First Amendment? The First Amendment applies to government regulation of speech. It does not apply to private companies' regulation of speech. My employer can regulate my speech while on company premises all the time. They have the right, and the courts have said, and they do, right? And they do, right? So there is no inherent right to free speech in the private sector. The free speech provision in the Constitution says the government will not interfere with somebody exercising the free speech. It doesn't say Google will not interfere.
Correct. And that's really important because a lot of times, but I do think that employees can bring this up to the HR departments. If we have courageous employees who can go and talk to the HR department and talk about how, as part of diversity and inclusion, they may not feel included because now there's a policy in place that unfairly targets them. And especially if there's a caste education seminars, there will be done by groups like Equality Labs. You can complain about that, saying, here's a bigoted organization you're bringing in that is essentially called our community Nazis and has openly asked for dismantling of our religion. So that can be done, and that has been done in places. For example, I believe in Google that was done when employees complain about Equality Labs, and that Google's talk was canceled. The talk was canceled. So that can be done. So I would recommend people to be vigilant about that and do take steps to express your concerns to your HR department. There was also this one. Okay, why would Cisco agree to a Caste re-education as part of a settlement? They're a financial bigger force. Wouldn't it be better for to redeem their brand and to fight hard and not be found guilty?
Well, they would never be found guilty, right? Any settlement that they will enter into would be without admitting guilt. So that is a basic argument about making a case go away. So from Cisco's point of view, they would simply say, we will agree to do this, but we will not concede that we actually discriminated against John Doe, and everybody will be happy, because this is about getting people to admit things and pay off money rather than somehow visit justice. Because to be honest, for a multimillionaire like John Doe to argue that justice was not done, by the way, he's still working at Cisco while Sundar is out. Right.
That's correct.
It's not as if somehow he's been, cut to the streets because he's Dalit and Sundar Iyer is a Brahmin. Right? So it doesn't work. So at the end of the day, there are two things which folks on this call can do. I think we have articulated very strong reasons why you should get involved, because it may affect you next. And the next question is, how can you get involved? With SB 403, the best way to get involved is definitely writing to your senators, writing to your Congress, writing to your representatives, writing to your city councilors, mayors, anybody who would listen. Tell them why SB 403 is a bad idea and why it will put Hindu Americans at risk, because it is now declaring open season on anybody who's quote unquote perceived to be upper class. That's all it takes. You can take them to the cleaners. And if you don't have the wherewithal to fight a big lawsuit, then what do? You either end up doing time. Well, civil cases, you're not going to do time, but you end up writing a big check, or you just concede and simply do what they ask you to do, which is, add caste to these policies and so on and so forth. So yeah, it's very important for people to get involved by writing to senators, writing to people, writing to your own companies, getting HR briefed on this case. There's a very thin line to be walked. You should brief HR on this case, but not necessarily bring about and say, well, HR should do this, because then it's an invitation for the HR to say, okay, fine, we'll just write a policy that way. The other big way in which the participants can help us is by donating to a legal fund that we are assembling to challenge the constitutionality of caste-based laws. So we need your support. We need people to donate as much as they can. And we need people to do it fast so we can build up a war chest that we can use for legal defense, just like the Jewish community has a legal defense fund. The Hindu community should have a legal defense fund. We are putting one together. Please contribute. Pass the word around. Ask your friends, neighbors, everybody else to do both. Contribute to CoHNA, as well as write to your senators, and if you need any help on how to word it, CoHNA has the CoHNA website, and we can paste the website link in that. The CoHNA website has information that you can use. You can compose your own message, or you can use the standard messages and add your own to what we are saying and amplify. Right. So this thing has to only crack under relentless pressure, and we have to apply the pressure.
Yeah, one interesting question that was put out here is that can SB 40 protect the so-called upper caste from discrimination by a lower caste? Very interesting, and I'll share my thoughts, and maybe Suresh, you can, and maybe Vivek can. What's interesting is they have already defined in SB 403 who is a oppressed person and who is not an oppressed person. So they have basically said that oppressed people are Dalits and Adivasis, and everybody else is essentially not oppressed. So according to me, while it may appear so, the chances of that being applied are very, very slim. because you're already looking at, it's like a downward, like you're just looking at one stream essentially, not the other way around.
Yeah, and that is the line on which this law is likely to be found unconstitutional, because it is so selective in how it applies and who it applies to. And it's also, yeah, so for example, if Julia Roberts, who identifies as Hindu, can she be sued for caste discrimination by one of her employees who happens to be, say, Asian American or happens to be Dalit? Can they sue Julia Roberts? Probably, because she's the one with the deep pockets, right? But would that be reasonable to say that, Julia Roberts, even though she is born and brought up as an American, she has embraced Hinduism and therefore has inherited the caste prejudice, which is essentially the case that's being made, which is if you are a quote unquote upper caste, you never, ever, ever get past it. You're always upper caste and you're just looking for an opportunity to suppress somebody. I don't think any of our experiences, real life experiences, come close to that. So, yeah, I mean, can this law protect an upper caste Brahmin, quote unquote, from being sued by, by being discriminated against by a quote unquote Dalit? Yes, in theory, but in practice, who are you going to believe, right?
Yep, absolutely. All right, let's see. I have posted, by the way, I have posted a fundraiser that we are having on Sunday, April 23rd in the Bay Area. We would love for having anybody who's from the Bay Area attend. I have just posted the link there as well. Somebody mentioned that the Fox Rothschild link doesn't work, the one that's given in the chat. You could just type in Fox Rothschild Cisco case and it should pop up. We'll I don't know what to do, but I mean, we can try to post it again, but.
Here, let me just post that link up again.
Yeah.
Because I had it pulled up, so give me a second here. Yeah, just going off of what you said, I don't even think in theory, quote unquote, upper caste can be protected just because of the way that it's defined. There's a protected category, there's a not protected. So even in theory, I don't think an upper caste could sue under this, which is why, like Sureshji said, it would just have to fall for unconstitutionality rather than trying to work within the bounds of SB 403. Got to get rid of it.
Okay. I
So
think we're
more questions we are at the top of the hour. So
yes, we are at the top of the hour. I think we had a lot of good questions. A lot of people said, yeah, we'll have the webinar link for people who may have missed it. We'll have to just process a few things here and there, but overall we'll post the link. Thank you all for joining the webinar today. We had a great participation, and we look forward to hearing from you. Please join the fight for SB 403. Check out CoHNA.org, CoHNA.org for more information, to donate, to follow us on social media, to join our newsletter, and many things, and to get involved and become a member, because only through involvement and membership can you really make a difference. So please do so, and we're here for you. Thank you and namaste.
thank you, namaste. Shubharatri.
Namaste.
Namaste.